All right, we're going to move on and start part 2 of the Civil Liberties section. This part is going to cover the First and Second Amendments and how those elements of those two amendments are applied to the states through the 14th Amendment. All right, so the First Amendment collectively can be interpreted as freedom of expression. And this slide is showing quite the contrast, as you can see, that freedom of speech is one of those liberties protected by the First Amendment. Even speech that is hostile or offensive, such as the views expressed by the KKK members in this particular photo, cannot be prohibited so long as they do not incite illegal action. Okay? And so you can imagine how difficult it is for this police officer to stand there while the KKK is using their freedom of expression to foster the views of the KKK. All right, so let's look at the First Amendment guarantees. The First Amendment has lots of different elements, so we're going to start with the freedom of religion. Okay, so this is what the First Amendment says. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And remember, one of the founding principles of the nation was that of religious freedom. But note also the tension in the First Amendment. There's really two parts here of the religion part of the First Amendment. No establishment of religion, this first part here, no law respecting an establishment of religion and protection of free exercise thereof. So there's two parts. This no law respecting an establishment, that's restrictive. Protection of free exercise is enabling. So there's really two clauses. There's something called the Establishment Clause and there's the Free Exercise Clause. And they're applied to the states and local government through the 14th Amendment. So these First Amendment freedoms associated with religion are applied to the states through the 14th Amendment. So let's take a look at the Establishment Clause first. Okay. The Establishment Clause prevents Congress from establishing a religion. It also prevents, through the 14th Amendment, states from establishing an official church or religion. It also says that the government cannot prefer one religion over another. So the government can aid religious institutions as long as it doesn't favor some over others. And this has typically been interpreted to mean there is a wall of separation. Okay? So what kind of practices are considered unconstitutional? Well, there's one case called the Everson v. Board of Education in 1947. This is the case that applied the Bill of Rights to the states through selective incorporation. In this particular case, the Supreme Court has upheld the use of state tax money to transport students to private religious school. So they upheld the use of state money to transport students to parochial school. The decision is based on the grounds that buses did not directly aid the religion, but merely helped all children in the community proceed safely to and from school. So they ruled that some aid can be incurred, that you can aid religious institution as long as it doesn't favor some versus others. So if you're going to bus children to school, private or public, as long as all children are being bused to school, that's not considered unconstitutional because you're not favoring one group over the other. You're getting all children to school. Okay. But generally speaking, what the government wants is a wall of separation between churches that are established and other types of institutions. Okay. So what actually constitutes establishment? This is difficult since religion is so much a part of one's daily life. Think about public meetings that are opened with a prayer. Congress opens with a prayer. Coins are inscribed with "In God We Trust." We have chaplains in the armed forces. So how do we know whether or not the government's trying to establish one church over another? The court attempted to clarify this establishment issue with what is called the Lemon Test and it's out of a court case that occurred in 1971 called Lemon v. Kurtzman. That's Lemon v. Kurtzman in 1971. It's known as the Lemon test, and there's 3 parts, so you're going to want to write this down. The Lemon test says that whatever aid is being given has to be, number 1, for a secular purpose. A secular purpose, secular meaning non-religious. So that's the first part of the test. The second part of the test is that the aid's effect was neither to advance nor to inhibit religion. Its effect was neither to advance nor to inhibit religion. So that's the second part. And the third part says that the aid must not foster excessive government entanglement with religion. So if the aid passes those 3 tests, the government is going to say that it's fine. If it doesn't, then it's going to be declared unconstitutional. So the aid has to have, number 1, a secular purpose. Number 2, its effect was neither to advance nor to inhibit religion. Or number 3, it must not foster excessive government entanglement with religion. So using this criteria, the Supreme Court has ruled and has been consistent in striking down such practices as Bible reading, non-denominational prayer, or even moments of silence for meditation. Now, I know that many of you might have gone to a high school where you had a moment of silence. If no one in your community sued to have that ended, then it's probably ongoing. Okay. The recitation of prayer in public school is prohibited, and this was first decided in 1962. In addition, no Bible reading in public schools. This was decided in 1963. And even a moment of silence law in Alabama was struck down in 1985. However, student-led prayer at football games is even considered unconstitutional. But that doesn't mean it still doesn't go on, because most of the time the members of the community are in favor of that. It is unconstitutional to pay the cost of teachers' salaries or instructional materials in parochial schools, because this practice would require excessive government control and surveillance to ensure that funds were used only for secular instruction, and this would involve excessive entanglement. So again, using the Lemon test, they argued we can bus kids to school, but we're not going to pay for teacher salary or instructional materials for private school, because that would require too much monitoring, too much excessive government control or too much entanglement to ensure that those funds are actually being used for what they said they're being used for. Okay. Well, other types of things that are considered to be unconstitutional are Christmas nativity scenes on public property that's considered to be an official endorsement of Christian beliefs. But if the display was accompanied by other non-religious items like a Christmas tree, Santa Claus, reindeer, it would simply be taking note of the season and not an unconstitutional endorsement of religion. So a nativity scene sponsored by City Hall, for example, on City Hall property is going to be constitutional within the context as long as there is some other non-religious or secular symbols of the holiday. So again, reindeer, Christmas tree, things of that nature. Okay. School vouchers are some additional recent court cases. So if we think about what a school voucher is, a school voucher allows you to take your child out of one school and put it into another school and have the state pay for it by using a voucher. Okay. In 2002, the court upheld a law in Ohio that allowed students to receive a tax-supported voucher to attend either a private or parochial school if they were attending a failing public school. Okay? And the argument was that it didn't violate the Establishment Clause, since students had a choice between secular and religious education. So in this particular case, if the school is failing, students would get a voucher, that is, the city would pay for that education, and they had a choice between going to a public or a parochial school. Okay, and the court ruled, since they had a choice between two different options, that they were providing not providing a a specific religious teaching, that they were indeed providing the student with an opportunity to go to one school or the other, and they were just paying for the student to go to school. Okay, so kind of to wrap up the Establishment Clause, I know that was a lot of information, but basically the Constitution and the First Amendment as it's applied to the states through the 14th Amendment prevents either the federal or the state government from preventing an official church or an official religion. Government can aid religious institutions as long as it doesn't favor some over others. And they really want to have this wall of separation. So how do we know if the aid establishes religion? That's the Lemon test, the 3 parts that I told you. And then I gave you some examples of what is considered to be unconstitutional and what is not. All right, let's talk about the Free Exercise Clause. The Free Exercise Clause prohibits Congress from interfering with your right to have free exercise of religion. So therefore, the federal government and states cannot restrict your religious beliefs and practices. But keep the following in mind. Beliefs are absolutely protected. You can believe whatever you want, but religious practices may be restricted. The Supreme Court has never interpreted the phrase of freedom of religion to protect any conduct carried out in the name of religion. So, for example, in 1879, the Supreme Court ruled that polygamy could be outlawed by Congress in the Utah Territory, even though some Mormons argued that it was part of their religious faith. Okay, and the Supreme Court reasoned that Congress was deprived of all legislative power over mere opinion. Remember, they can't tell you what to believe, but Congress was left free to reach actions which were in violation of social duties. And in this case, the social duty was the issue of polygamy. Okay. So the court has ruled that the government can outlaw religious practices that threaten the health, safety, and or welfare of citizens. Okay. So let me give you a couple of examples. Children with life-threatening illnesses, the court can compel medical intervention even if the parent's faith doesn't believe in the use of modern medicine. The Supreme Court ruled that the government can outlaw religious practices that involve human sacrifice or ceremonial use of drugs, such as peyote. Okay. You can't kill someone in a human sacrifice and say that it's part of your religious practice. You can't kill animals and say it's part of your religious practice. That's because whether you're claiming it as a religious practice or not, killing people is illegal. The same with ceremonial use of drugs. Drugs are illegal. You can't claim that it's part of your religion. Okay. And this has brought forth what is called the valid secular test. Individuals must comply with valid and neutral laws, even if these laws restrict their religious practice. So the restriction of drug use was not passed to discriminate against any particular religion, but as a general restriction against all drug use. Okay. But sometimes this valid secular test can be difficult to apply. So for example, in the Wisconsin v. Yoder case in 1972, the Supreme Court sided with Amish parents who refused to allow their children to attend any school beyond 8th grade, which was a violation of Wisconsin state law. And the Amish refused to allow their children because they felt that the high school exposed their children to worldly influences and values contrary to their religious beliefs. The court agreed in this particular case, pretty much making the Amish a protected class. Okay. This brings us to the issue of creationism. The Supreme Court held that a law, which was in Louisiana at the time, requiring the teaching of creationism along with the evolution in public schools was an unconstitutional establishment of a religious belief. Okay. So the Supreme Court has held that requiring the teaching of creationism along with the evolution is unconstitutional because you're trying to establish a particular belief. They have moved on to deal with the issues of intelligent design. And the idea of intelligent design is the concept that there are certain things in our universe that was best explained by some intelligent cause and not particularly the cause of natural selection. Okay. And so there's an overwhelming majority of the scientific community who believes that intelligent design is not a valid scientific theory, but is considered junk science. Okay. So the U.S. Supreme Court and other federal courts have ruled as unconstitutional a public school district requirement endorsing intelligent design as an alternative to evolution in science class on the grounds that its inclusion violates the Establishment Clause of the First Amendment. Okay. All right, so basically creationism is considered to be a teaching that tries to establish a religious belief and therefore is considered unconstitutional by the courts. All right, so when it comes to religion, there's freedom. There is the Establishment Clause and the Free Exercise Clause. All right, let's talk about the idea of freedom of speech and freedom of the press. So this whole idea includes freedom of conscience, the press, the assembly, petition, and the Supreme Court has interpreted the freedom of speech as extending to symbolic acts of political protest such as flag burning that you see here. On several cases, most recently in 2006, a resolution for a constitutional amendment to ban flag burning has passed the House of Representatives but has never found support in the Senate. So as long as burning the flag is done as a form of political speech, it is protected by the Constitution. So the Constitution says that Congress shall pass no law abridging the freedom of expression. Okay? And in protecting speech, the Supreme Court uses what is called the strict scrutiny test, which places the burden of proof on the government to show that a law is unconstitutional. The idea of strict scrutiny is that speech should be protected almost absolutely, but some forms of speech aren't. Okay? Political speech tends to be protected, symbolic speech, assembly. Other types of speech is going to be more conditionally protected, things covering libel, slander, obscenity, things of that nature. So the first case that really deals with this is a case called Schenck versus the U.S. in 1919. And in this particular instance, the Supreme Court established what is called the clear and present danger doctrine. And here the court upheld the conviction of Mr. Schenck, that's a rendering of him on the right, who had circulated materials urging men to resist the call to military service during World War I, and this was a violation of the 1917 Espionage Act. So the court wanted to draw a distinction between peacetime and wartime. So the clear and present danger doctrine became the standard to determine when speech can be restricted. According to this doctrine, only speech that creates a serious and immediate danger can be restricted. Of course, this is later replaced with the imminent lawlessness action test, but starting in 1919, the court instituted what is called the clear and present danger doctrine. So according to the court, the speech has to have a clearness and a seriousness of expression and has to put people in immediacy of danger. And so this is where Oliver Wendell Holmes said that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. So when it comes to speech, the court ruled that the mere advocacy of revolution, apart from action, is protected. Here the Supreme Court drew a distinction between advocacy of an abstract doctrine, that is communism, and an advocacy of a concrete action, and argued that his action was considered a clear and present danger. But through the 14th Amendment, the court has been able to limit the state's ability to restrict expression. Okay? So for example, in the Brandenburg case in 1969, the court expanded the clear and present danger doctrine to include clear, present, and imminent danger. So not only does the speech have to conjure up clear and present danger, but that danger has to be imminent. And Brandenburg was a member of the Ku Klux Klan who was convicted of advocating violence in the state of Ohio. And so you have these 12 hooded figures gathered around a large burning cross making speeches about revenge on the government, about sending people back to Africa, back to Israel. And this Ku Klux Klan meeting was led by Clarence Brandenburg. He's later convicted of assembling to advocate crime, violence, or unlawful terrorism as a means of accomplishing political reform. So he's found guilty by the state of Ohio. In 1969, however, a unanimous Supreme Court decision declared that that state law that he was convicted of was unconstitutional. And the justices wrote that constitutional guarantee of free speech does not permit the state to forbid advocacy of law violation, except where such advocacy is likely to produce imminent lawless action. Okay. So the court is basically saying you can advocate the violation of law all you want. You can tell people, you can talk about it, you can discuss violating laws all the time. Unless your speech produces an imminent lawless action, your speech is going to be guaranteed. So even when we don't like what is being said, as long as that speech doesn't cause an immediate or an imminent lawless action, that speech is going to be protected. So the court moved from a strict scrutiny test to an imminent danger test, that you have to go beyond a clear and present danger. You have to show that that speech is going to lead to some imminent danger. So the court ruled that the state could not repress freedom of expression that advocates violence or unlawful use of force, except when doing so directly produces imminent lawless action and is likely to produce such action. So again, not only does danger have to be clear and present, it has to be imminent. Okay. So the court has used this imminent lawless action test to rule that even hate speech is protected. The First Amendment doesn't allow for government to silence speech on the basis of its intent. And this protection isn't just related to hate speech. So neo-Nazi rallies, KKK rallies, the only thing the government can do is regulate the time, place, and duration of such type of speech. Okay. So, of course, this is an issue today where you might see on college campuses that they're enforcing policies that ban racist, sexist, homophobic, or otherwise insensitive speech. Okay. But hate speech by itself, the Supreme Court says, cannot be restricted unless it incites imminent danger. Then we have symbolic speech. There's more to expression than what comes out of our mouths. And so we are instantly aware of the different types of ribbons people wear, for example. So red ribbons for AIDS, blue for speech, yellow ribbons that we see is for the safe return of service people representing us overseas, pink ribbons for breast cancer. That's all represents a form of expression. And according to the text, symbolic speech is protected by the Constitution, including wearing armbands, KKK robes, burning the flag. But keep in mind, the court's protection of symbolic speech is very much less substantial than its protection of verbal speech. But again, the burning of the American flag is protected as long as it's symbolic speech. In that case, in terms of burning the flag, is Texas v. Johnson in 1984. There's something about expression called prior restraint, and this involves the press. And basically, we don't allow prior restraint. The court has generally ruled that prior restraint is unacceptable. And what we mean by prior restraint is telling a newspaper beforehand you can't print something. You can't print a news story. You're trying to restrain the newspaper before it takes action. The government cannot prohibit speech or publication before the fact. And the classic case is the New York Times versus the United States in 1971. This is also known as the Pentagon's paper case, where the government tried to have the New York Times stop printing an article about what was going on in the Vietnam War. The court ruled on the side of the New York Times and says we don't deal with prior restraint in the United States. All right. There's some types of expression that's going to have limited protection, and that deals with libel and slander. Libel and slander are communications that wrongly damage an individual. Libel's the written word, slander is the spoken word. Libel and slander have never been protected by the Constitution. Proving it is difficult because you must show that the words that someone printed or the words that someone spoke were made with actual malice or reckless disregard of the truth. Okay. Well, then there's obscenity. Obscenity, pornography, has never been protected by the First Amendment. And the biggest problem is trying to define what is obscenities. Okay? Justice Potter Stewart in 1964 admitted he can't define pornography, but said, "I know it when I see it." And that kind of describes what we think of when we think about things that are obscene. Okay? The first attempt by the Supreme Court to define obscenity was in 1957 in a case called Roth v. the U.S. in 1957. And here the court said that the appropriate test for obscenity is whether or not the material affected the most suggestible member of the community. I'm sorry. Here the court said it's not whether the material affected the most suggestible member of the community, but whether it appears to excite lust to the average person. That's what prurient interest means, to excite lust. So the court argued in 1957 that it's not whether or not the most innocent in your community is going to be offended, but does the average person get excited, lustful if you will, if they observe whatever is being shown. And in doing so, they have to apply contemporary community standards. In other words, today's standards, and this could change. So for example, what was considered obscene in the 1950s is not what is considered obscene today. If you think about television in the 1950s, the I Love Lucy show, Ricky and Lucy weren't even shown together in the same bed. And today on public television, you see all kinds of things that would never be seen as appropriate in the 1950s. So the prurient interest test is, does it excite lust in the average person? Are you applying contemporary community standards? And is it utterly without redeeming social importance? That was the test in 1957. And this broad standard made it very difficult for any material to be deemed obscene. So the Supreme Court tightened the standard in 1973 with the Miller test. And here the Supreme Court made the standard of obscenity to be determined by, first of all, local rather than national standards. And secondly, whether the object lacks, quote, serious literary, artistic, political, or scientific value. So in the Roth case, there were three parts to the test. Does it excite lust in the average person? What are the contemporary standards? And does it have any redeeming social importance? The Miller test says we're going to use local, not national standards for community standards. After all, what's considered to be obscene in Huntsville, Texas may not be the same as in San Francisco, for example. And secondly, does the object in question lack any serious literary, artistic, political, or scientific value? So if it lacks those things, then the court might deem that particular object to be obscene. All right. Well, that leads to information on the internet or cyber porn. And this is one of the most important issues today dealing with pornography on the internet. Pornography has never been protected. So what do we do about the internet? And most of the public is concerned with the ease of the offensive material that is available on the internet. So Congress added an amendment to the Telecommunications Act of 1996 called the Communications Decency Act. And the idea was to regulate the online transmission of obscene material. Well, in 1997, in the Reno case, the Supreme Court struck down that particular act of Congress, saying it suppressed speech that adults have a constitutional right to succeed. So the Supreme Court is ruling that the government may not limit the adult population to messages that are fit for children. And this is an ongoing issue about what's available on the internet, and it's basically up to the parents to provide some sort of protection to their children about information found on the internet. All right, that's a lot of information about the First Amendment. Let's very quickly talk about the Second Amendment and the right to bear arms. And what the Second Amendment says is that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. All right, there's really two interpretations of this amendment. One view is that the Second Amendment confers an individual constitutional right. Okay, the idea that the right of the people to keep and bear arms shall not be infringed. So many people look at this as an individual right. After all, colonists were concerned with tyrannical government and saw armed individuals as a protection against despotic government. But many constitutional scholars argue that the Second Amendment protects only the collective right of the state, the security of a free state to have a well-regulated militia. And this view focuses on the first part of the phrase well-regulated militia. And these scholars stress that the fear of tyranny by the anti-federalists was that of a tyranny of a centralized government over state governments, and not so much against the individual person. So this is left up to people's debate. Do you interpret the Second Amendment as the right of an individual to bear arms, or is this really the collective right of the state to be able to protect society at large? All right. As you may imagine, this is a big debate in politics about the right to carry arms, and we see this going on college campuses where many people in different states want to allow the carrying of weapons on college campuses, particularly after the Virginia Tech event that happened a few years ago. And so this is an ongoing debate. And so where do you stand on the Second Amendment? Most people believe that the Second Amendment, 73%, guarantees the right of Americans to have to own a gun, while only 20% believe that it only guarantees rights of state militia members to have a gun. All right. So where do you stand on the Second Amendment? Okay. Kind of think about that, and we're going to take a break.